Good evening, everyone. We're waiting for a few more people to come in, then I'll be introducing the program. Thank you all for joining us this evening from wherever you are, whether you're here at East Brunswick Public Library or out in Zoomland, wherever that may be. My name is Melissa Hosick. I'm the Adult Programming Librarian here at the East Brunswick Public Library. We are very excited for this presentation tonight on Planning for Your Child with Special Needs by Tina James Esquire. And based out of South Amboy, she'll tell a little bit more about what she does. And we will be recording this. However, we will be ending the recording so she can answer some brief Q&A. Remember, she cannot give direct legal advice, but she can try to answer some at least basic directional questions. So thank you all for joining us.
All right, well, thank you everybody who's here virtually and who's here in person today. My name is Tina James. I am an attorney. I practice in South Amboy, New Jersey. I've been practicing for a little over 13 years now, and I focus on estate planning, but I also focus on families that have kids with disabilities, whether they are a child, a young child, or an adult. There's a lot of planning that's involved. We're going to go over that tonight, but that is a significant part of my practice. I've been doing that for the last 6 years. Prior to that, and I just like to tell people about my background, I had been doing a lot of litigation, right? And so I was litigating these issues, whether it was probate issues where we were fighting over a will or a trust or a guardianship issue, right? And so that gives me a different insight into these issues because I know how we can better plan to prevent some of those difficulties between family members from happening. So jumping in, and I want to give us an overview of what we're going to cover tonight on this topic. We're going to go through 6 different major categories. We're going to talk about public benefits. I'm going to talk about, these are going to be things that your child may or may not be entitled to as an entitlement. These may be benefits that are needs-based, meaning based upon their income. And we're going to go through those requirements so you understand that. We're going to talk about educational entitlement, what they're entitled to if they have a disability. I'm going to transition into estate planning where we're going to talk about special needs trusts. That's very significant if you have a child and they are receiving those benefits later on to make sure that we protect them and they're not jeopardized, and how we can use that trust to make sure that they are in place for the longevity of their life. We're going to talk about that transition to adulthood, what happens when they turn 18. And that's significant, right? Because they become an adult. They have legal obligations at that point. And we're going to talk about whether a guardianship is necessary or whether or not other supports may be necessary. If a guardianship's not appropriate, how else can we support that individual? And the last little bit of information I'm going to talk about is those New Jersey ABLE accounts. It's a very special type of savings account for an individual with a disability, and we'll talk about how that can be beneficial in their life. So jumping into the public benefits, there are 2 types of public benefits that could be applicable if you have a disability. Now, we think about Social Security. We know about Social Security retirement, right? They take a part of your savings when your paycheck, they put that towards your retirement. We're not talking about Social Security retirement. This is either the disability insurance or supplemental security income. There's these 2 different types. One of them is needs-based. And what that means is that your income is below a certain amount, so you need it to survive, and your assets are below a certain amount, so you need that as well. The entitlement Social Security disability, on the other side of that comes from your work history, meaning that you have worked and contributed into that, and that's an insurance payout that you receive. And so sometimes an individual with a disability will be able to claim benefits under their parents if their parents have SSDI, right? And if their parents' work history. But for the most part, individuals that have a disability may be entitled to, most likely are entitled to supplemental security income. Prior to 18, they won't be eligible because the government's going to look at mom and dad's income. They're going to see that mom and dad make too much money. But once that person turns 18, we look at their individual assets and income limits, and that's usually when they can qualify. The other big benefit that we need to think about is Medicaid. Medicaid's that health insurance that we know it provides long-term care insurance for someone who might need a nursing home, or maybe their disability is so severe they might be in a long-term care facility. Medicaid would cover those types of medical services. Now, I want to mention Medicaid is very, very important because while not everybody may need that healthcare piece, Medicaid unlocks other supports and services in the state of New Jersey. And the example is the Division of Developmental Disabilities, and I'm going to talk about that in a second on the next slide, they provide supports and services to individuals with an intellectual disability or developmental disability. So these might be individuals that have autism, that are on the spectrum, maybe they have Down syndrome, and they would get services and supports through DDD, right? In order to be eligible for those supports and services, they must be Medicaid eligible, right? And so that's an important piece to remember for them. Now, needs-based benefits, some other ones that are out there are food stamps, legal aid, payment assistance, and those are not necessarily always available to someone with a disability, but more so someone who's below a certain income threshold, right? Housing subsidies, again, might be available to individuals that are just impoverished below that line, but also support and services through DDD. We talked about that. We're going to talk about that a little bit more. They have group homes. They have supported apartments. So they have housing support as well. So on one side, we have needs-based, and the other side, this entitlement. The entitlement is because you have paid into that system. So that's where the SSDI, that disability insurance, comes from. Medicare, that's usually when you apply for retirement. You are eligible for Medicare. A lot of elderly people are on that, but also folks that are on that disability insurance, that SSDI, are also eligible for Medicare after a certain time period. The other thing that's an entitlement that somebody's just entitled to is education, right? And we're going to dig a little bit more into that education, but that's also something that's an entitlement. So these are our three big ones that we think about when we have an individual with a disability. So I'm going to go through these, and that's that supplemental security income. Normally, I have families start that application when the individual turns 18, because below that age, they'll look at mom and dad's resources and they won't qualify. That is a monthly stipend. It's a money amount, $750 to $950, somewhere in that ballpark, for food, clothing, and shelter. That's what it's meant to cover, is the basic necessities for a person. We know that doesn't go very far. That is just a very small amount, but that's the intention, that this money would be used for those things. In order to be eligible, that person also needs to meet a definition of disabled, right? So Social Security has their own definition of disability. And as I mentioned, there's going to be income limits and asset limits. And I want to talk about that. Asset limit is going to be very, very important for us when we talk about estate planning, because that individual that's receiving the benefits needs to keep their assets below $2,000. That's going to be our magic number, right? So we're going to talk about that with some examples. But that's actually a very low threshold to stay underneath from month to month. Now, Medicaid, we talked about that being a healthcare benefit, but you need to also meet those specific income and resource limits. You need to stay underneath them. And unlocking the supports and services for the DDD, right? And this is what provides things for an adult, that like a day program, transportation, housing, maybe a personal aid. Once they turn 18, parents, and we'll talk about this, may make the decision to have their child stay in school up to the age of 21 if they have a disability, right? And we're going to talk about certain things happen during those years that we focus on. But after the age of 21, then what? That's where the supports and services from DDD kick in for us. That's when that becomes really important for us to be concerned about. So this is the stage of what we need to think about in terms of benefits that are out there. And I want to talk about how we plan our lives to make sure that the person who's entitled to it can receive it and we don't jeopardize it. So moving into, well, let's talk about education. Sorry, I missed education here. Talking about this educational entitlement where they can stay in school to the age of 21, it means that the school district where they live will provide them with a free and appropriate public education up to the age of 21. Free means obviously it shouldn't be a cost to the parents. Appropriate means that the individual has been evaluated for what their needs are and that they have an IEP, an individualized educational program, that matches those needs and is designed to make sure that they are progressing in school and meeting goals. It also needs to be in the least restrictive environment. So if we have a general education classroom, and that person can be educated in that classroom with an aid or with some supports. Example, I have a student who is deaf, he's hard of hearing, and he can be educated in the general education setting with an interpreter. right? That's the least restrictive environment. A little bit more restrictive is where you pull a child out into a special education classroom. More restrictive is where maybe they're placed out of district in a specialized school, right? And so the idea is for them to be with their peers as much as possible so that they have that social growth with their peers as well, in addition to being educated in that environment. What's really important is that parents are entitled to participate in this process along the way. They are an equal member of that educational team and their voice should be heard at those meetings. So with your child, we need to make sure we have evaluations done so we know what they need in the classroom, what sort of supports that are appropriate. We need to have that IEP done that tells us this is what their plan is and how those supports are going to apply. And that gets reviewed annually, the IEP, and about every 3 years is when their new evaluation should be done. They are entitled to stay in school up to the age of 21, and usually between the ages of 18 to 21, what they're doing is working on those transition skills. The transition planning does start earlier than that, but they're working on whether it's vocational training, learning, maybe going out to the community, maybe volunteering somewhere, maybe getting some hands-on experience with the business. That's what happens between those key ages. Maybe it's college planning, but transitioning to where they're going to be after the age of 21. So moving into, like, this is the estate planning topic, and I want to talk very, very briefly first about why would we need a special needs trust. A lot of families come to me and they're like, I was told I need an attorney because I need a special needs trust, but they don't understand why. So I'm going to use this example where you have mom and dad, and we have a home that's worth $300,000. We have 2 children. One has special needs, one does not. If we do not do anything, mom passes away, all of the assets are going to pass to dad. Okay, passes to the surviving spouse. Dad passes away, they now pass equally to those 2 children. So I talked earlier about that $2,000 threshold that we needed to stay below. Well, now that person just inherited $150,000. So they are $148,000 over the limit, and that has now jeopardized their benefits, right? So those needs-based benefits that we talk about that get them to that that DDD eligibility and get them the healthcare that they might need, possibly their housing, could be jeopardized if mom and dad don't have an estate plan in place. What that estate plan does is mom and dad have a will, and we're going to go through these documents in a second, so we dig down and look at them. Mom and dad have a will, and they say, I want to leave first to my spouse. My spouse passes away, then I'm leaving it equally to my 2 kids. However, my child with a disability, we are going to leave it to his special needs trust or her special needs trust. That's where we're going to leave it. So it never goes to that individual directly. It goes to the trust, which is like its own pot waiting to collect that asset. And that's called sometimes a supplemental needs trust, special needs trust. It's there to supplement their benefits. So let's dig down. When we talk about an estate plan, these are sort of the questions that we're looking at, that we're trying to answer. Something happens to you and you pass away. Number one, who's going to handle your estate? Who's going to wrap up those final affairs? Do maybe a final tax return for you, close out your bank accounts, pay any last bills. Who is that person going to be that you trust? Second, what's happening to your assets? That's where I said we have to care about that for our child to make sure that it either goes to them in a way that can be used to supplement their benefits, or we don't jeopardize what we just spent a lot of time setting up for them. If we don't have an estate plan in place, the court will require they're not an executor, they're an administrator, but the personal representative, the person handling the estate, will be required to post a bond. What does that mean? Your estate is worth $300,000. They have to get a bond, which is basically like an insurance, to be insured up to $300,000 just to handle your final affairs for you, right? Now they just learned mom's passed away, dad's passed away, my brother's passed away, and the court's telling me I have to go and get a bond for $300,000. Nobody wants to hear that, right? So in your will, a lot of times we have legal language in there. People are like, what is this? What does this mean? We say we're waiving a bond. Why? Because we don't want the person we love and trust who's taking care of things for us to have to go through that, right? So we want to make sure we waive that bond. The other big question is, who's going to raise my children? Right? If they are minors, we need to be concerned about that. We need to think about who is going to be taking care of them, but also if they have a disability. Once they turn 18, we still may need somebody taking care of them, right? Sometimes they might be under guardianship. So we need to say, who's going to be our successor guardian? Who's going to take care of them after we're not here? And in our will is what we're going to talk about for those. So The will, we're going to decide who's the executor. That's the decision maker when you're not here to close out your estate, to handle your property, do your final tax return. Assets, how are they going to go? We're going to make sure that we leave that portion to the special needs trust. The guardian, we're going to talk about who is going to raise my minor children, who might raise any children that are disabled as an adult. If we have minor children, let's say that example where we have the 2 children again, that one child who's inheriting that $150,000, they don't have a disability. Do we really want them getting $150,000 at 19? Like that might not be a good decision, right? Maybe it is, maybe it's not. Most of the time it's not. Or if they're 16, what's going to happen? It might be paid into a court registry and it's going to be held by the court until they're 18 years old. Do we want that either? Not really, right? So we want to make sure if they're young, who's going to oversee this for them? And usually I'll recommend we do a minor trust until the child is 25 years old. Gives them an opportunity to go through college and get settled. And when it's in a minor trust, I just want to be clear about this, the child can still access it. They just need to access it through the trustee, right? So if they're going to college and they need it for books or they need it, they just have to say, hey, can I have access to this for X, Y, and Z, right? So they're not just taking it, blowing it on a car or a party, they're using it responsibly. Not all of your assets are going to be covered by your will, right? Your will, we need to think of this as the instruction sheet for certain assets, and usually it's bank accounts, it might be a house, your personal property, but there's other assets that we have that have their own beneficiary designation on them. So they might be retirement accounts, life insurance policies. Those are governed separately by that instruction sheet that's a part of it, that beneficiary designation form. So if we're going through the trouble of setting up an estate plan where we are doing a will, creating a special needs trust to cover some assets, we need to sit down and talk about what other assets you have. Was it a retirement account? And make sure that doesn't go to your child as well. We need to make sure we direct that over to the special needs trust. So that way everything is pointing in the right direction and we're not leaving anything out. The next part we're going to go through is special needs trust here. Now, I've been primarily talking about a third party or a supplemental needs trust. And it's a third party because it's set up by mom and dad, right? Or mom and dad, grandma, grandpa, anybody can set this up, but it is not set up from the individual, right? The individual, him or herself, who has the disability. There's another type of trust that's sometimes called a first party trust, Medicaid payback trust, or sometimes D4A, that's the name of the section of the statute. That trust is set up by the individual, him or herself. We don't usually want that trust, but I'm going to explain what it is. That accidental inheritance that I talked about, mom and dad pass away, that $150,000 now accidentally went to that child and it's about to jeopardize their benefits. We have to go to the court. We apply to the court, we petition the court and ask permission, like mother, may I, can we put it into a first party special needs trust, this Medicaid payback trust? It's expensive, it's costly. The trust, the court will most likely say yes, unless there's reasons why they shouldn't, but that's been far and few between. But the downside to this is, besides it being costly, is that at the end, when your child passes away, any money that's left over in that trust goes to Medicaid. It goes to the government. That's why it's called Medicaid Payback Trust, right? So they are going to then receive, the government will receive anything that's there. You have an individual with a lifelong disability and they start on Medicaid when they're 18 years old. They probably will end up with what's called a Medicaid lien, because that's the value of all the services Medicaid's provided throughout their life. That Medicaid lien will probably be close to $1 million. These are like high Medicaid liens, right? So anything that's left over in that trust goes right back to them. Now we can plan by having that third party special needs trust. That's the one mom and dad set up, grandma, grandpa, whoever. We set that trust up. You get to decide what happens with your money after your child passes away, right? So it may be, hey, I'm putting this in the trust for, my son, Andrew, using my husband's name as an example here. So put it for him, but when he's not here, I want it to go to my grandkids. I want it to go to an organization. I want it to go to the East Brunswick Library, whoever it is who's ever supported you. You can decide that. You get to control it. This is your hard-earned money, right? So let's make sure that you provide for who you want to provide for. So 2 distinctions. A lot of times people will come to me and say, I'm scared, I don't want to do a trust because Medicaid's going to get all the money, but it's knowledge, right? We need to know there's this type where they don't, and there's another type where they do. The trustee of a trust, right? We really need to think hard about who this is going to be if we're not here. this person needs to know your child very well, right? They need to know a couple things. Number one, the rules of the trust, what it can be spent on and what it can't be spent on. But they need to know your child's likes and dislikes, right? This is going to be things that it's going to supplement their life. Have they been going on a vacation every year that we want to continue? Do they need it for a new iPad or a tablet or maybe new furniture in their home? Whatever that may be, that trustee needs to have the hard skills, that record keeping skills to be good with that, but also the soft skills to make sure that they're communicating well to the beneficiary, right? Funding the trust, and this is how does the money get into the trust, right? How do we fund it? And I talked about that estate plan, mom and dad, your house, that's just one example. You know, you can direct a portion of your estate into that trust. Some individuals will take out a life insurance policy and they will name the trust as the beneficiary of the life insurance policy. Right? There's a whole bunch of different ways how you can fund it, but most often it's funded after mom and dad pass away. When they're no longer here, whatever they've left as their inheritance, it's funded. The key is that we don't want to jeopardize anything when mom and dad pass away. It's traumatic enough to have these problems in place. So we want to avoid that. How can the money be used? It's a supplemental needs trust. So it's meant to supplement the benefits the individual is receiving. So early on, I talked about that supplemental security income covering food, clothing, and shelter. This is meant to be for all of the other things, the vacation, the iPad, the tablet, the phone. It might be, you know, sometimes they might have a car. It could be everything that supplements their life. It's not meant to replace what they're receiving from the government, right? So there might be something like maybe they need horse therapy and that's not covered by Medicaid. The trust could cover something like that, right? And so, like I said, the person governing this, the trustee, needs to make sure that they understand those rules or that they know where to find the answers to those rules to make sure that they're using it correctly. Power of attorney, durable power of attorney, just an abbreviation there. This is a document, part of your estate plan, big picture, but this is used in place to have someone make decisions for you that are legal and financial on your behalf. It's called durable because it is in place immediately. And this is used banking transactions, maybe signing a lease, maybe doing things with a house. We often want to name a backup to ourselves. God forbid we're in a car accident, something happens. But if you are a guardian for someone with a disability, you might want to name a backup guardian, right? Durable power of attorney can only be used for up to 6 weeks in an emergency for that piece before you'd have to go to the court to have a permanent guardian or a temporary backup guardian in place. We want to make sure we have a power of attorney in place who can act on your behalf if you cannot. And also to name your own guardian, right? If you're incapacitated and somebody needs to take care of your own affairs, who do you want? Who would you want handling that for you if you're not able to? So that power of attorney document is a very powerful document. It's a very important document. The other document that goes along with that, like the sister group of documents, are the medical ones. And who's going to make medical decisions for you while you're alive if you cannot, right? So we always want to make sure that we're naming somebody to make those decisions on our behalf. And if you're a guardian for someone else, if you're the guardian of your child, who's going to make their decisions if you can't even make them for yourself, right? And so that's why we want to make sure these documents are in place. I always want to do a HIPAA release, both for the person that we name under that durable power of attorney and for who's ever making financial decisions or medical decisions. Because you might have somebody doing financial decisions for you. Maybe they're paying your bills and they call up, what's this medical bill for? Why is she being charged for this? What are these charges? And the first thing they're going to say is, you're not the patient, we can't talk to you about this, right? So we need to make sure that we can cover this. So if you're not here, they can handle everything on your behalf. Your end of life decisions, these are difficult conversations to have with people, difficult things to think about, but what do you want to happen if you have a condition that's terminal, right? Do you want further treatment or do you want to have them, terminate life support, right? And these are things you should spell out because your family during that time, they want to know what your wishes are and you don't want them to be guessing what would mom want, what would dad want. At least if we tell them, then they have guidance as to how to make those decisions for you. So shifting gears back out of the estate planning part, talking about that transition to adulthood. Your child, if they're 16, 17 years old, we're going to start thinking about things like, are they staying in school beyond that age of 18? Are they going to be there beyond that? Will your child need a guardian? Right? This is not necessarily a black or white question, right? Because a lot of individuals are maybe independent in some areas, but maybe not in others. We're going to take a look at that. And what's that transition going to look like after school, after the age of 21, right? So there's a lot of planning that goes in. We really need to start the thinking process around the age of 14, 16. If they're going to need a guardian, we want to be planning for that probably about 17, a little bit after they turn 17. And then transitioning beyond that, we're going to be talking about that transition plan with their school annually at that IEP meeting. What's going to be the next steps and how are we getting them there, right? What's going to get them to that next place? So digging down into guardianship, and I'm going to talk about the standard, and it's going to sound very vague. It's very legal. The standard of when somebody needs a guardian is, can they manage and govern their own affairs? Like I said, very vague, very legal. What does that mean? You know, sometimes I can't manage my own affairs. I've had a rough morning, but that means that we're looking at 4 different major areas. Can they make financial decisions? Can they make medical decisions? Can they make legal decisions? Can they take care of themselves? Can they dress themselves, right? And so one of the things that we dig down and we look at is, do they have seasonally appropriate clothing? If we left them on their own, would they know to wear a jacket today if it's a little bit chilly out? Are they going to wear shorts in the middle of the winter? Socially appropriate clothing. Would they show up to a wedding just wearing, you know, some shorts and a t-shirt, or do they know maybe at a funeral, we dress a little bit different, right? Are they going to understand those social cues? Can they cook for themselves? Can they make a bowl of cereal? Can they make more than a bowl of cereal? Can they use the microwave, the oven, the stove? Financial decision-making. We gave them $20 and they walked into Wawa to buy a candy bar. Are they going to know the correct amount to be charged? Are they going to get the right change? Are they even going to wait for the change? Or are they just going to leave? Decision-making with medical decision-making. Can they weigh the risks and benefits of a medical procedure? The doctor said, hey, your tonsils need to come out. Are they going to understand what that means to go under anesthesia? Is that better for them or not better for them? If they were signing a lease when they turned 18, would they understand the consequences of not paying their rent, or maybe not paying the car payment if they're leasing a car? Are they a vulnerable adult? So can someone take advantage of them, maybe on the internet? Maybe they're capable of, using a computer and they might do online gaming. I had an individual who, in the course of, I think it was like a 6-month window, 23 times had been hacked because he kept making friends online on that game, and he kept giving out his password and information, and eventually his parents said, okay, enough's enough, right? Bank accounts were hacked, other things were hacked, and we need to put some restrictions in place, and guardianship in some areas may be appropriate and others it may not be. The court divides it in 2 different ways. Guardian of the person, this is their body, right? Where do they live? Where do they sleep? What school are they in? Do they go to the doctors? Are they alive and well? Guardian of their property, this is the money in their account. This is their bank accounts, the assets that they have. This process, a guardian has to be court appointed. We can't just wave a magic wand and say this person's the guardian, though I wish, but we can't start until after their 18th birthday. And I mentioned before, we're going to start planning around their 17 and a half, that part, because we need to schedule 2 doctor's appointments that are within 30 days of each other and are going to be within 30 days of when we file with the court. So if they're going to turn 18 on June 15th, I need those doctor's visits to happen after May 15th, but before June 15th. So on June 15th, I can go ahead and file with that, right? So reason why I say we start early, because sometimes if you have a neurologist or if you have other doctors that are difficult to get into, I want you to have enough time to make those appointments so that way it's in our nice little sweet spot for that window. We file with the court. We're going to need those 2 doctor certifications. The court will appoint an attorney to represent your child, right? That'll be a separate attorney. I represent mom and dad. Separate attorney represents the child. That attorney will just meet with the family, interview them, do a report for the court. There's going to be some background checks that have to do. There's some guardianship training. And then we have a hearing. Usually it's about 60 days out. In Middlesex County, we're pretty fortunate that as long as all of the ducks are in a row, all the paperwork is in, I get a call from the court a couple days before the hearing date that says, everything looks good, you don't need to appear, we'll just go ahead and enter the order on Friday. Right, so it's really nice that we don't have to do that. In some cases, judges will say, I want you to still come in for the hearing. Now, nothing wrong with that. Usually what that means is the judges just want to meet the family. They want to just get to know them, and go ahead and do the guardianship and grant it then. Afterwards, a guardian needs to make sure they do annual reporting. They need to say to the court, my child, they're an adult now, but they're alive and well. They still need a guardian, but yes, I've taken them to the doctors and everything is good. We need to think about who is going to be our guardian when we're not here. Who's that successor that's going to be behind us? And that's something we need to think about if we are a guardian. So sometimes guardianship is not appropriate, right? Sometimes an individual is independent, but we still have a lot of emerging skills and they need support. These, as long as they have capacity, meaning they understand what they're signing and doing, we can have them sign some of those documents that I talked about for your estate plan. We could have them sign them for yours, a power of attorney, a medical directive, and an educational proxy in some cases. So that's basically saying they want mom and dad still involved, or it could be somebody else. Now, the key with this, and this is important to know, if they have capacity to put this in place, they also have capacity to take it away at any time, right? So if they get mad at mom and dad, they can rip it up. They don't have to name mom and dad, right? This is freely, voluntarily a decision that they have to do. If you say to me, well, guess what? They're going to just, rip it up when they get mad at me because they can't regulate their emotions. They're not going to understand anything. And they're going to put themselves at risk. And wait a second, we have a vulnerable adult. Do we understand what we're doing here? Example I have an individual I'm working with, the family, the one I said was hard of hearing. He understands his disability has to do with hearing, right? And so he signed an educational proxy, basically an educational power of attorney, saying mom and dad should still be involved in that educational process when he turned 18. He understood that. That was not a problem for us to do that. Mom and dad won't get information once that child turns 18. So that means maybe your family doctor will continue to allow mom and dad to be involved, but you could run into the situation where they're in the emergency room and the doctors are saying, mom and dad, you need to wait outside right now, right? Because they're 18, they're an adult, and you no longer have the right to be in there with them, right? And so a lot of times folks will be able to get by without doing the guardianship at 18, 19, 20 because the child's still in school. But once they turn 21 or once an emergency happens, then we're scrambling to get everything done. But like I stressed before, they need to have the capacity to understand that decision if they are making that decision. So last topic we're going to cover before I open it up to questions is the New Jersey ABLE account. This is a savings account. It's specific for individuals that have a disability. Now, what happened is it falls under the 529 savings code. This is the section of the IRS that applies to college savings. Eventually, the government realized that not everybody goes to college. And mom and dad were saving for kids to go to college and they were stuck with money in these 529 plans. So they created a new section that applies to individuals that have a disability. So they have to have a disability that started or manifested before the age of 26. So our folks with lifelong disabilities, this applies to them. You can put up to $17,000 into this account, and it does not jeopardize those benefits that they would be receiving. There's a catch. There's always a catch. It always sounds too good to be true. You could put more in this account if they are working. Right. So if they are working, you can contribute up to the poverty, what the poverty limit is. And it's usually like another $16,000. So you could put even more into this account, like some from their wages and maybe some from mom and dad. Here's the catch. Any money left over in this account when they pass away will go back to Medicaid. Right. So there's always going to be a catch. However, this is what I call this as a tool. Right. We need lots of tools. We may not need them all the time, but sometimes they are very, very helpful. Number one, you can spend it on a qualified disability expense. This is a broader definition of what things can be spent on, right? So I said that supplemental needs trust can't supplement the benefits we're receiving. And if SSIs for food, clothing, and shelter, which is housing costs, the trust shouldn't be spending money on housing costs, but an ABLE account can. An ABLE account has a broader definition, which includes housing costs. Right. So we can move money from a trust over to an ABLE account and then spend it from the ABLE account. So we can use it as a tool. This was very, very helpful for a lot of my families during the pandemic. What happened is they needed to stay under that $2,000 threshold limit. Maybe they received about $900 every month from Social Security. The world shut down and they couldn't spend anything. They couldn't go anywhere. So the next month, now they're up to $1,800. Now the government sends out a nice little stimulus for $1,200. And now we are definitely well beyond our limit. And so instead of jeopardizing their benefits because they're over that $2,000 mark, we put money into an ABLE account, right? We put it in here. Now, when the world reopened, we spent it. But in the moment, it kept us from jeopardizing those benefits. It got put somewhere and we just didn't spend it just randomly on things that we need. So I tell families that this is a tool. I want you to know about it and want you to know that it's out there. You may never need it, but it's just an opportunity in case those things happen in your life. Sometimes I will also have, and I'm just going to mention this, the accidental inheritance where grandma might leave a grandchild $5,000 or $10,000. I'm not going to spend the money going to the court, petitioning the court. I'm going to put it in an ABLE account, right? This is a lot less oversight. There's a lot less involved, a lot less expensive. So we use this. It's a tool that's out there. So I just want people to be aware of it, to know that it's there. So I know we have folks that have joined us online as well. So I'm just going to flip to our last slide here and just open it up. If folks have questions about the things that I've covered tonight or any other topic that's out there, I'm happy to